Um, okay, so hello everyone who's starting to join us, and welcome to this panel on Russia's war and implications for international law and the United Nations. Just a couple of logistical things. We will be taking Q&A, but it'll be typed in, so you can use the Q&A function on your screens, and we will get to those questions after the panelists have spoken. Professor Packer, who is our moderator, please, the floor is yours.
Thank you, Orest, and good morning for those who are joining in North America and those elsewhere. Welcome for this special event. It's an honor for me to be able to work together with the Ukrainian Canadian Congress, with the Ukrainian Canadian Bar Association, with my Human Rights Research and Education, my colleagues in the Human Rights Research and Education Center at the University of Ottawa, and with the Embassy of Ukraine to Canada as the partners in organizing this event. Obviously, it's a very timely subject. There's a lot of discussion and some confusion, I dare say, about what are the possibilities and the implications for international law and for the United Nations in this extraordinary situation. For me personally, it's a special occasion to link arms again with friends from Ukraine, colleagues from the many, many years that I've had the honor to work with Ukraine and other actors. Again, with former Ambassador Nölke, who we had the pleasure to work with some 20 years ago, I dare say, in the OSCE, in a period of time which was somewhat more hopeful, a lot more hopeful and more functional. Today, we're facing a grave, grave situation. And I think it's important for us to be sober in our understanding, be very careful in our analyses. We have a stellar group of persons of genuine expertise who will share their views on the situation and some of their thoughts about what the implications are for international and the United Nations. Before that, I'd like to do something that maybe doesn't happen online and is extraordinary and a bit unusual. Given the gravity of the situation, I'd like us just to take a moment together to reflect on the already unimaginable losses of just 4 weeks. There are now in excess of 10 million displaced persons in Ukraine. That's in excess of the entire population of Quebec. So if we can just fathom what has happened, thousands of persons, not only combatants, but many thousands of civilians have lost their lives destroyed, homes and futures destroyed. And I think we need to take a moment just to appreciate the suffering, the loss, and the risks that are not only directly affected, but really affecting us all. So if you would join with me just for a moment, I will stop speaking and we'll just have a sober moment of silence to reflect. Thank you for joining in that brief acknowledgement and reflection. We have a collection of really impressive speakers. Their bios are available online. We will share them through the chat also. So I'm not going to read, we wouldn't have time to go through the impressive and substantial personal accomplishments and professional accomplishments of our speakers. Unfortunately, I have to inform you that the Honorable Erwin Kotler is unable to join us today. He's unfortunately fallen ill. We hope that this is just like many people suffering seasonal colds and so forth. And so we wish him well. And We know he's been working feverishly and successfully on many issues around the world, and it's been great to be able to work with him. So we will unfortunately miss his input today, and we will think of him. But that then turns us to our other three speakers. We are waiting at the moment for Dr. Gnatovskyy, who will join us imminently, any moment, from Ukraine, or I believe from Ukraine. And then we will have our speakers, former Ambassador Nölke and Canada's Ambassador to the United Nations, Bob Ray. I'll just say a few words briefly. I'll introduce Dr. Gnatovskyy when he arrives. So pending his arrival, I will proceed to invite former Ambassador, and actually I should call you Dr. Nölke, or Sabine, whom I've known very well as Sabine for a long time, has a really impressive professional career as a career diplomat, one of Canada's eminent ambassadors, and as a lawyer. She joined the Canadian Legal Service, the Canadian Foreign Ministry as a lawyer, and she has held important positions, including at an ambassadorial rank in a number of postings, not least in The Hague, where she was also accredited to the Organization for the Prohibition of Chemical Weapons. She served as a co-counsel in a case before the International Court of Justice, so she has a practice experience before some of the top level institutions. She's worked at the OSCE and elsewhere, and within the government had directly relevant responsibilities at Director General and Director level. And she has, for all of her sins, also earned recognition internationally, including an honorary doctorate. Former Ambassador Dr. Nölke, I invite you to address us briefly with some general thoughts or specific thoughts with regard to the implications of international law and the United Nations.
Thanks very much, John, and thank you to the Ukrainian Canadian Congress and colleagues for the invitation to attend this very timely, unfortunately, and important event. I have to say, my heart stands with Ukraine on these issues. I will make absolutely no apologies for that. My heart has also been in my throat for the last 3 to 4 weeks, watching what has been unfolding in this beautiful country of yours. Both the suffering, of course, and the heroism of the population of Ukraine have been first and foremost in everyone's thought. Now, for me as an international lawyer, of course, I've also looked at what has been unfolding from that perspective, which can be somewhat dry on occasion, somewhat practical, I suppose, when you really want to be emotional. But I think this is what we've been called upon to do here, is talk about practical ways of how we can use international law to address these issues. I've been, as an international lawyer, appalled at the virtual shredding by the Russian Federation of every possible part and norm of the international rules-based system, starting from the provisions of the Charter of the United Nations, going into international humanitarian law, the law of armed conflict, including the Geneva Conventions, but also the older Hague provisions on the conduct of hostilities, the indiscriminate use of weaponry, and the trampling of human rights at home in Russia, again, in respect of those individuals there, the brave and courageous Russians protesting the actions of their own government. How to hold Russia responsible? Now, there's been much talk, of course, of war crimes, the crime of aggression, etc. But it's my impression that Ambassador Ray, as Canada's representative currently as the Vice President of the Assembly of States Parties to the International Criminal Court, will be dealing with the individual criminal responsibility aspects of the actions we've been seeing unfolding. So I want to look a little bit at state responsibility. How the state of Russia is actually can be held liable for the actions that it is responsible for. And under international law, I think everybody knows this as a basic principle. States are responsible for international wrongful acts against other states, whether that is the violations of treaties, a violation of UN Charter, which of course also fundamentally is a treaty, or other actions that they're taken. The principles of state responsibility have been set out by the International Law Commission in its draft articles on state responsibility. Those, of course, in and of themselves are not binding because they are not a treaty, but they do reflect customary international law. And most importantly, they also reflect the law that has been applied by the International Court of Justice over several decades now, and by its predecessor as well, the Permanent Court of International Justice. That includes the law pertaining to reparations for violations of international law and international norms. Now, in that context, the Ukrainian case that was brought before the International Court of Justice with the hearing and the order given last week, the interim order rather, that case in its ultimate outcome will seek reparations. The order of the International Court of Justice last week was an interim measures request and ordered the cessation of hostilities. But of course, that has been utterly ignored by Russia, as we all know. It has not yet addressed the issue of reparations because the merits of the case themselves have not been determined yet. But the ultimate goal will be and can be reparations for Russia's violations of international legal norms. So let's park that thought for a moment and move on to a thought that I've been often asked to express by colleagues, namely, can we use assets that have been seized pursuant to sanctions to satisfy those reparations? That's a very practical question. The international community is currently sitting on virtually billions of dollars from the Russian central bank, individual Russian oligarchs. Can that money be liquidated and used to help Ukraine rebuild at the end of the day? The United Nations Security Council would have the power to make such an order. It did so once before. It did so in the Iraq-Kuwait situation in 1990-1991. UN Security Council Resolution 687 actually set up a claims commission whereby individuals, corporations, governments affected by Iraq's aggression against Kuwait could seek financial reparations. Now that was, and it paid out several $1 billion in pursuit to that. Of course, that was from Iraqi oil proceeds seized. Now, of course, we've already mentioned at the beginning the dysfunctionality of the UN Security Council currently. And of course, if you were to engage in a resolution under Chapter 7, International Peace and Security, to make such an order, Russia would veto. End of story. And it is one of the unfortunate facts that at this point, the veto is a very difficult thing to get around. But we now have a case before the International Court of Justice, which brings the actions which raises the possibility of raising the issue under Chapter 6 of the UN Charter. And under Chapter 6, the UN Security Council is empowered to deal with the Pacific settlement of disputes. And in that case, when the Security Council makes any decisions in response to a dispute that has been brought to its attention, under Article 36, sub 1, it can recommend appropriate procedures or methods of adjustment. That is the language in the Charter. Under Chapter 6, the Russian veto is eliminated. Why? Because again, going back to the Charter, Article 27, sub 3 says if the Security Council deals with issues I'm paraphrasing here, where on the Pacific settlement of disputes, a party to the dispute must abstain from voting. In other words, the Russian veto would be neutralized. Now, can the Security Council then under Chapter 6 make decisions and order states to do things that it normally would do in a legally binding manner under Chapter 7? I would suggest, yes, it can. A decision is a decision, and decisions are legally binding on member states. So there is a path there for the Security Council to actually make a ruling. Of course, I'm being optimistic here and hoping that that China will not exercise its veto in respect of such a decision, because it could do so under the Charter. However, there's a possibility to do that. Now, in other words, if the ICJ ultimately were to order reparations, or frankly, at any stage of the dispute, as per the Charter, they don't have to wait for a decision of the ICJ. The UNSC could then call on member states to use seized Russian assets to pay for these reparations, or at least raise this as a possibility and invite states to do so in a non-legally binding manner. Alternatively, of course, the General Assembly, if the Security Council refuses to make such a decision, the General Assembly under Article 12 and its residual powers could do so, just as it a couple of weeks ago made a finding that Russia did in fact commit an act of aggression against Ukraine. And so there are possibilities there for the United Nations to act on reparations and allowing Russia essentially to be held accountable in a financial way for the damage it has inflicted on Ukraine. Now, what does that then mean for member states? I had a brief look at our applicable bits and pieces of legislation. There are a little, we have a patchwork of legislation that deals with asset freezes. We have the Freezing Assets of Corrupt Foreign Officials Act, the Special Economic Measures Act, the Proceeds of Crime Money Laundering Act, and the United Nations Act. The United Nations Act only gets triggered under Chapter 7 decisions, so that is out. The others allow for asset seizures, but they don't necessarily allow for payment of those seized assets to a third party, such as Ukraine. So we may need, if we wanted to go this route of using Russian assets to assist Ukraine in its recovery, we might need to enact additional legislation to make that possible. And of course, a UN General Assembly or UN Security Council decision addressing these issues would be greatly helpful as a hook to do that. Now, finally, I was asked, John asked me, because of my past as Canada's representative to the Organization for the Prohibition of Chemical Weapons, he's asked me to address what would happen if Russia were to use chemical weapons. Now, hopefully we won't get there. Although I have to say that given Russian pronouncements accusing Ukraine of wanting to use chemical weapons, accusing Ukraine of having biological pathogens, given the way it's used, Russia has used the Genocide Convention as a pretext for its military actions. I sense that they might want to go a similar route with regard to violations of the Chemical Weapons Convention and the use of chemical weapons in this conflict, as has been done, of course, by Russia's close ally, Syria, with Russian military support and acquiescence already in Syria. So I must say I'm a pessimist, but I do hope that the indication by the international community that this would be a red line will actually hold, but we shall see. But if Russia were to use, or if chemical weapons were to be used in Ukraine, Ukraine can ask the organization, the OPCW, for a fact-finding mission to confirm the use. And thanks to a decision by the states parties of the Chemical Weapons Convention in 2018, the OPCW now also has an investigative and identification team that allows the attribution of such findings. In other words, they can finger point and say, yes, the munitions that were used to deposit these chemical weapons are of Russian make, there were Russian planes in the neighborhood, etc., etc. It looks like it was Russia. They have done this in Syria already. Then what happens? Of course, the OPCW itself has no enforcement mechanisms, but the good thing, the one thing to note is that Russia doesn't have a veto in the OPCW. It is one of 193 member states. And despite fierce lobbying, it has so far failed to make any inroads in having the OPCW make findings in respect of chemical weapons use, in particular in Syria and Iraq and elsewhere. So the OPCW can make a finding that Russia has violated and breached the convention, which would then add to the overall tally of Russia's violations. The mechanisms of the OPCW are empowered to pass their findings on to the United Nations, and then we go back into the cycle of, possible Chapter 6 or General Assembly recognition, acknowledgement decisions by the Security Council or the General Assembly. But in any event, Russia would be liable again as a state for any violations of the Chemical Weapons Convention and the consequences thereof to Ukraine. And I think I'll stop there. I'm sure there'll be lots of questions, but also we have 2 more speakers. So hopefully I didn't run too long.
Thank you very much, Sabine. No, there's a lot on the table, and it's very good to have your expertise to respond to things like the prospect, the ominous invocations and references to things like chemical weapons, which unfortunately are not beyond the imagined. So I'm now going to invite, and it's a pleasure to meet Dr. Mykola Gnatovskyy. Thank you for joining us. Dr. Gnatovskyy is a professor in the Institute of International Relations at Taras Shevchenko National University in Kiev. He took up that position after his studies in international law, where I note that you earned your Master's of Law in 1999, the same year that Mr. Putin became president, and I think importantly, the same year that the Russian Duma adopted the law on the protection of compatriots abroad, which I think is a core issue at the origin of the situation. Dr. Gnatovskyy then earned in 2002 his doctorate in international law, specialized in human rights law, in international practice. He was a member of the European Committee for the Prevention of Torture, a very impressive and practically very effective institution in the Council of Europe in the implementation of that fundamental treaty, for which Dr. Gnatovskyy was actually the vice president. And he's also the first vice president of the Ukrainian Association of International Law. So he has many publications and more things to say about his profile. But I cannot think of a more qualified person to address us today on this very important subject. Dr. Gnatovskyy, please, you're welcome to address us.
Thank you very much, Professor Pecker, for this extremely kind introduction. And first of all, I would like to thank very much the organizers of this webinar. And it's a great pleasure to be amongst you. And I must, of course, apologize for joining you with a delay. As somebody from Ukraine, I currently experience a lot of logistical challenges, so many apologies for this. And I'm very happy to be with you, and everything seems to be working just fine. And I apologize for missing part of the webinar. Let me just very briefly concentrate on the practical things with all the theoretical background, of course, which is there, and much of which has just been so impressively been explained by Ambassador Nölke. As a professor of international law and former president of the European Committee for the Prevention of Torture, I indeed worked in international humanitarian law, international criminal law, and human rights law more than anything else, but of course taught general international law for many years. And since the war started, I joined the foreign ministry of Ukraine as advisor to the minister, well, on a temporary and pro bono basis, but this is the only way I can serve my country effectively, in my view, nowadays. And there's what I would like to say about the current situation is, first of all, that I think I will not exaggerate if I say that we are dealing with the worst war and the worst violation of the foundational principles of international law in Europe since the end of the Second World War. And the gravity of this situation is such that it requires one, I think, to think a little bit beyond what we normally used to teach and preach, if I may say so, about the limits of general international law, about the possibilities of international criminal law, in particular, about the ways that international institutions such as the United Nations and other institutions can react to the violations of this gravity. And in practical terms, I think we should also, when we speak about the United Nations and state responsibility, and this is a little bit to reflect on what Ambassador Nölke has just been saying, we have to proceed from the fact that we have an act of aggression we deal with an act of aggression by a permanent member of the United Nations Security Council, the act of aggression that has already been established by a resolution of the United Nations General Assembly with 141 votes in favor, and this in itself, I think, should push us to look and to think a little bit outside of the box. So whenever we see that, and in this case we certainly see that the Security Council, within its competences under Chapter 7 of the UN Charter, is totally paralyzed, we have certainly been looking for other ways, or otherwise, what would be the purpose of the United Nations? I would say that this organization, under these circumstances, simply should either transform and find ways to react to what we see, or, well, disappear, and perhaps something else will come in its stead. So essentially, I see two major avenues, and this is what I work practically on, and what we are all, me and my colleagues, are thinking and working on very much over the last month. One of these issues is pretty much along the lines that Ambassador Nölke was talking about, and this would be ensuring state responsibility of the Russian Federation, and the only thing which one can realistically get hold of would be the assets of the Russian Federation, and also of the state-owned or state-affiliated companies, or companies close enough to the state concerned. And I think this there's many subtleties here, and overall this is a very complicated matter which I can't even sketch sufficiently clearly within 3 or 4 minutes. But I think that even the traditional approaches of international law, such as self-help and countermeasures, sanctions, this is all can be very useful. And ultimately, I hope the assets, Russia's assets, which have been frozen or will be hopefully frozen in various countries, should all go towards a possible claims tribunal or something along these lines, which would then be used to make up for the damage that has been inflicted on Ukraine. since the beginning of the war, and it continues every day, every hour, and every second. And the second major avenue I'm busy with, and also I think that everyone should really be, international lawyers should really be preoccupied with, are the issues of individual criminal responsibility for crimes under international law. And we have the full spectrum. At least three out of four core crimes have certainly been committed: the crime of aggression, crimes against humanity, and war crimes. And when it comes to genocide, when there's an armed attack which is being accompanied by statements such as this would be the final solution of the Ukrainian question, one would quickly recall already one dictator who was aiming at a final solution of a national question in Europe. And that would be very suggestive that, unfortunately, we cannot completely ignore the possibility that these crimes might amount to genocide, especially against the background of false claims of genocide, which have been used by Ukraine also to trigger the jurisdiction of the International Court of Justice in the case that has just been mentioned. So in terms of individual criminal responsibility, once again, there's two major avenues. One is crystal clear. This is the International Criminal Court. When it comes to crimes against humanity and war crimes, Ukraine has consented to the jurisdiction of the court. The court has been less than impressive, as always, in quickly moving forward. But nevertheless, it has, and now with more than 40 states also referring the situation in Ukraine to the ICC, and hopefully with more organizational and financial support that the International Criminal Court is going to be receiving, one hopes that it can impress everyone now, and it can finally prove that it has been created for a reason. So this one is fairly clear, and here, of course, these efforts must be complemented at a national level by Ukraine, but also by other states who have already started investigations using the universality principle, the universal jurisdiction, such as Germany, Baltic states, and others. And last but not least, something that I've been very busy with for the last 3 or 4 weeks, and what I think should really need to be fast-tracked, this is individual criminal responsibility for the crime of aggression. The ICC, unfortunately, has no jurisdiction over this crime. This is clear. And it is not going to get one because it would in any case require Russia's ratification of the Rome Statute and of the amendments, which one can't certainly count on. But I'm convinced that the idea of setting up a special tribunal precisely for the crime of aggression should be the right way forward. And there's several options how to set it up. I would refer you to the statement and declaration that have been announced at Chatham House on the 4th of March this year. I was amongst the authors, and together with Philip Sands and Dapo Akande and the former UK Prime Minister Gordon Brown. And it's been signed by over 150 leading lawyers and public figures. And there's a petition supporting it, which has attained almost 1.5 million individual votes already, and it's only growing. It's counting, I'm sure, will attain 2 million soon as well. And there are states which are at this stage ready to support this initiative. One can look at various options, and one can talk for hours which option would be the better. One, through an agreement with an international organization, or perhaps a multinational tribunal along the lines of a Nuremberg tribunal. Well, the ICC is also a multinational body. It has, of course, the universal ambition, but it's still a number of states who have signed this agreement anyway, the Rome Statute. But I think that this avenue should really be fast-tracked. The crime of aggression is legally much more straightforward than war crimes and crimes against humanity. There's much less to prove there. it's fairly clear, and you might have seen a model indictment for Mr. Putin that has already been drafted by two international lawyers who just did it in a matter of days. And of course, this can be further enhanced, and also there might be more, and there should be more people who should be charged with this crime. But in any case, this is very realistic. I fully recognize that it would be difficult to expect Mr. Putin and his cronies to be surrendered to The Hague or wherever in the coming months or perhaps years, but who knows, of course. But in my personal view, even an absentia indictment would serve a purpose. And also, not only politically, but perhaps legally, it might influence other issues, including the ones concerning compensation and assets and so on. But again, that is to be seen. So I think that again, when it comes to the assets and when it comes to individual criminal responsibility, this would be the major legal avenues, because otherwise, when we have a state which has already chosen to ignore a legally binding order from the International Court of Justice and has announced so. It has previously ignored a legally binding order on interim measures from the European Court of Human Rights. It has ignored the UN General Assembly resolution. There's whatever you decide further in whatever forum, that is going to be ignored. So you have to continue to proceed from the assumption that we have to be innovative and we have to be stronger than we used to be. Otherwise, I'm not sure there's any use in these discussions. And I'm really sorry to be saying this as a professor of international law with who's been teaching it for over 20 years, but unless we even push the limits a little bit. Now, given the extraordinary character of the situation, I'm not sure we are going anywhere. Let me stop here with my initial comments, and I will, of course, be delighted to participate in the further discussion. And once again, thank you very much for the invitation and for setting this up. Thank you.
Thank you very much, Professor Gnatovskyy. There's a lot there. I will just say that not only is this kind of egregious breach of a fundamental tenet of general international law, the respect of sovereignty, including the territorial integrity of a state, the worst violation, or let me say the most in your face, to use a commonplace term, a breach in probably since the Second World War. One might imagine maybe the intervention in Kuwait or a couple of others of a similar character. But I would actually say it's pre-Westphalian, because the fundamental assumption of the rules-based order is the principle of sovereign equality. And it appears here that the Russian Federation has simply jettisoned that foundational basis of the Westphalian peace. So we're dealing with something pretty profound here, which begs lots of questions about almost every other instrument that you've mentioned and so forth. And therefore is a threat to global peace and security. We have now, and it's my pleasure to introduce not only eminent Canadian specialist in international law. You mentioned Dr. Gnatovskyy specifically, international criminal law. I can't think of a better person right now to discuss this, because I understand, Ambassador Ray, you were recently at the meeting of the Bureau of the Assembly of States in The Hague, if I'm not mistaken, in your capacity as, I think, Vice President. So probably no one is as informed as Ambassador Ray about the actual situation. But let me just say a few other words. Ambassador Ray probably needs no introduction to Canadians for sure, and many people in the world. He is, of course, Canada's ambassador to the United Nations Permanent Representative in New York. He has had a long, it's such a long career and impressive. Let me pick one or 2 points, Ambassador Ray. I am very impressed that Ambassador Ray was 11 times elected as a parliamentarian, both provincially and federally. That's quite an impressive record, because it speaks to the confidence he generated in the citizenry. And to achieve that and to maintain that is no small feat by any means. in a democratic society, which I'm pretty sure Ambassador Ray can also talk about the rough and tumble of politics. So to have that kind of record is impressive. But also he's not just achieved so much in Canada, politically, provincially, federally, but also internationally for many years in the form of federations, through his other work abroad. He most recently, before becoming ambassador, of course, was Canada's, I think, the Prime Minister's special envoy, first of all, for the situation in Myanmar, where he wrote a impactful report on the Rohingya situation, which has some parallels to the current situation, not least the genocide question. But then immediately before becoming ambassador, he was Canada's special envoy for international humanitarian and refugee issues, which unfortunately are many and ongoing and now worsened. So without saying more, let me just say it's a pleasure, and Ambassador Ray, you're welcome to address the meeting.
Thank you so much, John, and thank you for your very kind introduction, which I really appreciate. But I also want to say how proud I am to be on the same panel with Sabine and Dr. Gnatovskyy, because I will have some things to add, I hope. But let me take what they say as the basis for my comments. I have no disagreement with what they've described as the overall legal situation. But I would start, as I often do these days, with a quotation from Blaise Pascal, who was writing several hundred years ago about the dilemma that we're currently in. It's more than a dilemma, it's a tragedy. And Pascal said something that is kind of obvious, like a lot of his thoughts are you say, of course, why didn't I think of that? But it's important to restate it. He says simply this: justice without force is powerless, and force without justice is tyranny. So the situation we're in is that Russia has adopted the policy of force without justice. That's exactly what they're doing. The act of aggression, which is unquestionably the case, the act of war, which is unquestionably the case, is the product of tyranny and is creating a tyranny. John has said in his comments that the issue is, does Russia accept or not the sovereign equality of its neighbor, Ukraine? And I don't think we have to go any further than speeches and texts and documents and articles that have been written by President Putin himself to appreciate the fact that he does not accept the existence of a sovereign, separate, independent, autonomous state, Ukraine, in his thinking. He says over and over again that Ukraine and Russia are one. He says over and over again that the Ukrainian nationalism is a foreign product, that it's not a genuine expression of the will of the people who are living in the geographic territory of Ukraine. And I think we have to understand this issue, because the comparison that I make, sometimes it upsets people, but I will do it again because I think it's important. Many of you will know that Russia fairly recently passed a series of laws in which they decriminalized domestic abuse. Domestic abuse is an expression of power. It's not about sexuality or anything else. It's about how some people control other people, in particular, how men control women. And in the course of doing that, men frequently refuse to accept the independence or the distinctiveness or the dignity of the other. And so you will frequently hear people say, this is private matter. This is between us. This has nothing to do with you. Police stay away, courts stay away, law stay away. Well, there are many Canadian lawyers who are listening, and they will know full well that in Canada, we've gone through this very real transformation of our law in creating equality between women and men, to say that the notion somehow that women would be treated as property, that women would be treated, the abuse of women would be treated as a private matter in which the state has no role, that's out the window. That's gone. That's long historically buried. But if you think through carefully what the implication of this is for how Russia is treating Ukraine, you see many of the parallels. Putin says, stay out. This is a private matter between us. This is none of your business. This has to do with a domestic matter. It's not an international matter. We don't accept the jurisdiction of the International Court of Justice. We don't accept the views of the General Assembly. And this is fundamentally the problem that we have. As Dr. Gnatovskyy has said very clearly, and I think he's right, we all know that the crime of genocide starts with an idea. And the idea is that some people don't deserve to exist. Some people are less than human. They will use expressions like gnats, crickets, vermin to describe other human beings, and thereby dehumanize them and thereby make it possible to kill them. And the great work that Lemkin did on the Genocide Convention spoke to this horrible reality and the need for us to address it through international law. So that's the first half of what we're dealing with. We're dealing with without question is criminal behavior, but we're dealing with a problem where we can identify, and this is, I think, the challenge that we face. This is what makes this discussion so urgent, is that we all have a responsibility on the Genocide Convention when we think it's happening to say, what can we do to intervene to actually stop it? And I think this is really the nub of where we are right now. And it speaks to the first half of Pascal's phrase, where he says, justice without force is powerless. If we had a law in Canada that said, you can't go through the traffic light, but don't worry about it, we're not really going to enforce it, and with nothing we can do because the trucks going through it are too big, we don't know how to stop them, we wouldn't have a law, right? We would say, if you don't have enforcement, you don't have a law. If you don't have the ability to enforce, then you don't have the rule of law. The rule of law requires enforcement. In his famous speech in Fulton, Missouri, Winston Churchill actually talked about this. People identify that speech as only talking about the existence of the Iron Curtain. But actually what Churchill was talking about was his vision of what kind of a world we need. He wanted to have an international police force. He said, you can't have strong justice without a good constabulary, which is a practical way of saying what we all understand. If you can't rely on the police to come in and enforce the law, then you are subject to the whims of a bully. And that's precisely the situation we're in at the international level. And I think the world is struggling at the moment. The United Nations is struggling. NATO is struggling. But above all, both NATO and the United Nations have this common feature, is that they're made up of nations who are making decisions as to what they can do to actually enforce the law. So the fact that there is a law, that we've created this very elaborate architecture that takes us to the ICJ, the International Court of Justice, takes us to the International Criminal Court, maybe takes us to the Human Rights Council for a tribunal, sets up a special tribunal for aggression, all the range of things that are there. They're critical, but all of them together, in order to be effective, require a political will to take it to the next step. And I think this is where we are right now in the world. I think we are all wrestling with this question of how do we take it to the next step? I have made a point of suggesting the last few days that when we talk about the veto, yes, the Security Council is dysfunctional, absolutely. The abuse of the veto by Russia to stop people from criticizing them by virtue of an act of aggression being carried out by a permanent member of the Security Council, by any stretch of natural justice or anything, you'd say you can't use your veto to do that, but they do it, and they will do whatever they feel they have to do in order to keep the world at bay. And it's not just to keep the world at bay, it's to keep the notion of the law at bay. My favorite description, one-line description of what is the rule of law. The rule of law is no matter how powerful you are, the law is always above you. There's always a standard above you. The rule of law applies to sovereign states because sovereign states are not absolute. If they're absolute, they'd be acting as rogue actors. Russia is now acting as a rogue actor. But the critical problem, and I don't have an easy solution because I think the world is wrestling with it, but I think we do have to wrestle with it, is how do we actually enforce what we know the law is? We know what Russia is doing is an act of aggression. We know it's destructive. It's creating loss of life, loss of moving millions of people, creating total disruption, food prices rising. The economic consequences of this are going to be dramatic for years to come. This is a calamity of extraordinary proportions. But we also have to take action in order to avoid things getting worse and avoid things further deteriorating from where they are now. And I think the leaders of the world are wrestling with this, leaders of our own country, of other countries, as they meet this week in Europe, and as we continue to discuss what further steps can be taken. There is a basis in not only in the NATO commitments that Canada has, but there are international commitments that we have by virtue of the Charter itself. And since other people have been quoting the Charter, as some of you will know, I carry my pocket Charter around with me in my pocket. And Article 51 of the Charter says this. It says, nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. So what does that mean? Well, it seems to me what it means is there an armed attack? Yes, there's an armed attack. Is there a right of individual self-defense? Yes, there is. Is there a right of collective self-defense? Yes, there is. So the question becomes, how do we put this into effect? Which brings me back to the veto that really matters at the moment. The veto that I think everyone has to come to terms with are the weapons of mass destruction, whether they take the form of dirty bombs, nuclear bombs, or the advanced use of chemical weapons. And we need to understand that this is not a theoretical discussion. This is a really practical discussion as to how, in fact, we could intervene in such a way as not to make things potentially worse or not to create greater self-destruction. I have to say, I can point to the challenge. I think we need to understand it. I think we need to understand the legal basis upon which people can intervene. Lloyd Axworthy and Alan Rock talked about this in an article today that I think a number of people have been reading in the Globe and Mail. One thing I think is very clear to me, and that is that no matter how eloquent we are in the UN, and no matter how many resolutions we pass, that isn't going to cut it. It isn't what we say as much as what we do. And so the collective actions that have been taken so far will have to intensify. And we'll all have to be aware of the very challenging circumstance in which we find ourselves, because it is intensely difficult. And finally, I think we have to continue to look for ways in which the crisis can be resolved, in which the damage can be limited, in which we can try to save as many lives as we can. We need to recall the expression that we're not going to find absolute solutions. We need to be as inventive and nimble as we can in finding whatever practical solutions we can that will maintain human life and maintain the integrity of the state of Ukraine. It is Ukraine that's at stake here, but it's more than that. It is the way we live and the extent to which, in sharing a planet with governments that are frankly dangerous, vicious, and tyrannical, how do we curtail and limit their impact? And I think that's not an easy dilemma to set out, but it's one that we have to recall. I think it's a testing moment and a defining one for all of us, for all of our institutions. And I think we have to do everything we can to see that they're up to the task. I'd be glad to participate in any questions, but I think I've gone on long enough, and I really appreciate the opportunity to speak to all of you and to be among so many good friends in a common cause. Thank you for the opportunity.
Thank you, Ambassador Ray. I note we have lots of questions and our time is short. It's always the problem in these kind of things. And certainly, I think there are many things from what you just commented upon that invite questions, and some are directed already to you. So, but before going to that, allow me to invite, and it's my honor to invite the Ambassador of Ukraine to Canada, His Excellency Andrei Bukovich, who will speak and is the representative of Ukraine in Canada. Ambassador, you have the opportunity.
Hello, distinguished guests, Your Excellencies, thank you for this opportunity to join this webinar today. Well, let me start with what happens. On February 24th, Russian invaders crossed Ukrainian border as thieves under the cover of night, with no chevrons on their uniform, no flag on their tanks. And the question is, if in the 21st century, in heart of Europe, such war can happen, a war beyond humanitarian law and humanity as such, if one and sole purpose of the war is to destroy entire nation because it has its own land, own culture, its own history, people of this country would like to speak their own language, if just one dictator can blackmail and terrorize the whole world, if all these war crimes and atrocities can comfortably coexist with all sophisticated system of international organizations, institutions, treaties, and agreements, then obviously this system needs a radical revision and, I guess, fundamental change. I'm afraid reforms are not enough in this point. The current international order is declared as the order of peace. The prohibition of the unjustified use of force is the cornerstone of modern international law and security as such. Nevertheless, if you are cynical enough, disregard humanism, and capable of controlling 140 million country, it seems quite logical to be selective in ignoring or following international treaties, or prioritizing some of them which suit you well, whichever helps you to achieve your personal goals. So why exactly that happens today with Russia and Putin? It seems that Putin used the same and uses the same tactic he has been using for years in Chechnya, Georgia, Syria, with little or no reaction at all. And after occupation of Crimea and Donetsk and Lugansk region in 2013, the response was too little and too late. And it's clear now the global security architecture, international organization, international humanitarian organization, democratic institution are unable to effectively prevent the horrors of war, with thousands killed, millions displaced, or help, at least to help millions to flee the war. The legal basis of the modern security architecture must be changed according to the challenges and threats of the modern world. This is what we see now, because it is very difficult to identify a single war crime that so far has not been committed by Russia in Ukraine. So using cluster bomb, phosphorus bombs, using civilians as the human shield for armed forces, shelling and bombardment of cities, houses, and residential areas, well, human trafficking, you name it, please. And it seems to me that the main goal for us all, lawyers, legal people, diplomats today, is to do everything possible that Russia cannot avoid legal, economic, financial, and reputational responsibility for all war crimes it has committed and keeps committing in Ukraine right now, for all crimes, for every ruined life, for every ruined house, and for every destroyed cities. And as we know, the time now runs absolutely differently for us who are now in this room and for those who are now being bombed, being airstriked, who are now in shelters in Mariupol, Kharkiv, Chernihiv, and other cities. That's why today's meeting, today's webinar is a very important step towards justice. The justice we all need, a justice which requires groundbreaking measures of international law enforcement to match these formidable violations of international law, ethics, and morale by Russia. And I use the word enforcement instead of application deliberately, because though I have an economic background, I still have some modest memories of international law course. And I do remember that one of the biggest difference between international and domestic law is the international legal norms has no element of sanctions as such. There is no international body that can effectively punish for violation or ignoring of international law norms. Do some say that general international law has such sanctions, reprisals, and war, but what if a state started a war of choice for no rational reason? What if the only reason is to exterminate the other state and people it represents? What if such state wages war against a state which has less resources and less military protection? Should we abandon the international law then? I believe no. And this is for, I guess, including for this distinguished audience, distinguished expert diplomats to answer these questions and to be effective in finding these solutions. I think it's a privilege to work in the area of international law, because it's your skill, it's a professionalism, is, if you wish, an art, how to transform a sort of philosophical concept and ideas into working legal mechanism. And this is, I think, what we have to do now. And my final comments, one more thing. I'm very pleased to see here Dr. Gnatovskyy, because 1999 is well known not only for what Putin has done or Russian Duma has done. I'm also graduated from International Economy faculty of our joint alma mater, and I'm very pleased to see him here and to guide this initiative on International Tribunal for Russian war crimes against Ukraine. I'm confident that this initiative is in very good hands. And at the same time, it's difficult to imagine and to probably understand the fact that some of our university friends who graduated from the same year, they will now live only in our hearts and memories because they died defending Ukraine with arms in their hands in this terrible, undeclared, unprovoked, and unfair war. Thank you.
Thank you, Mr. Ambassador, for those remarks, including the very sobering last comment. Our time is extremely short, and I can tell the persons, more than 300 persons who are part still of the webinar, that we have more than 30 questions, which we will, I'll come back to that with a practical solution in a moment. But before doing so, I do want to invite the president of the Ukrainian Canadian Congress, Alexandra Shishich, just to say some words, because not only as a co-organizer, principal organizer, but also for the voice of the 1.4 million Canadian Ukrainians who are feeling touched directly, not indirectly, many of them directly in the situation, I think it's important to hear. So you have the floor.
Thank you, Professor Packer. On behalf of the Ukrainian Canadian Congress and my colleague Jason Wojcichin, president of the Ukrainian Canadian Bar Association, I want to thank you all for joining us today, and in particular to thank our distinguished speakers for taking the time out to discuss this critical question. We are moved by your compassion and energized by the passion that you have brought to human rights issues throughout your careers. Thank you, Ambassador Ray, Ambassador Nölke, Chargé d'Affaires Bukvich, and Dr. Gnatovskyy, and of course, Professor Packer. It would be trite to say that I wish we were meeting under different circumstances, because today's topic is a difficult and painful one, which has been forced upon us by Russia's criminality. Ukrainian civilians, women, children, the elderly are targeted by a campaign of terror bombing not seen in Europe since World War II. The besieged city of Mariupol a few short weeks ago was a vibrant city of 400,000, now reduced to rubble. Mariupol will go down in history among European martyr cities like Coventry and Warsaw. And what is happening in Ukraine is a systematic murder of innocents by a member of the UN Security Council charged by statute and treaty to protect peace. We have addressed critical issues today for the international community to consider and act on. After World War II, US Justice Robert Jackson, the chief prosecutor at Nuremberg, stated that the wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored, because it cannot survive their being repeated. And yet, here we are. So it's those principles that were enunciated that today are under threat of Russian airplanes, cruise missiles, and artillery. We thank you for your considered views, and we look forward to working with you to take this to the next step, whether it's The Hague or Nuremberg too. And I fear that time is not on our side here, but thank you.
Thank you for that. In fact, let me just, in the few minutes we have left, pose a couple of questions, but I want to take up the point about time, because, and I know that it has often been said that we must ensure that the urgent does not become the enemy of the important. But here, I think urgency is the order of the day. We are only 4 weeks since this act of aggression commenced. As Ambassador Bukvich mentioned, even in that initial act, blatant violations of the norms and standards of international law, but we are on the precipice of worse. So with this in mind about urgency, where we know that Lady Justice classically takes time, and there are myriad practical problems around, for example, individual responsibility and criminal processes. I'm interested in the responses. Let me pose a question to Dr. Gnatovskyy. Under the Genocide Convention, for example, there are 152 states parties, including Canada. So this is not just a matter of the determination of the International Court of Justice. In general international law, there is an obligation between the states, in between all of them in multilateral terms. And that obligation, once breached, creates, under the law of state responsibility, duties and rights of other states to respond. So I'm interested to know, and for the audience, let me just say that there are 158,000 treaties registered with the United Nations, and there has only ever been about 200 contentious cases before international tribunals in the last century. So it's not a matter of court deciding this. There are 152 states parties to the Genocide Convention. Would you have some comment about what could be done now between the 152 states parties who could reasonably argue that there has been a breach of the Genocide Convention by pointing to the ICJ's provisional measures determination, and simply act now?
Thank you very much for this question, Professor Packer. I think there is no lack of legal basis for any collective action in support of Ukraine. I fully support what Ambassador Ray was saying about Article 51 of the UN Charter. I mean, the right to collective self-defense would be, I think, the #1 argument. And whatever state is ready to face Russia and defend the lives of civilians in Ukraine and also defend the sovereignty and territorial integrity and political independence of Ukraine, then the only thing that stops them is not any legal constraint. It's purely the blackmail that Russia would be using nuclear weapons against them, and because the statement has been as clear as it may be since 2014 that anyone who interferes will basically be nuked, and they will not hesitate to destroy the entire planet. So this is pure blackmail, and you've mentioned the Genocide Convention. Fair enough. I think the obligation to prevent genocide is precisely this is erga omnes obligations. But there's plenty of other erga omnes obligations, starting with the prohibition of the use of force. I mean, the regime of state responsibility would also be erga omnes. Crimes against humanity would also be erga omnes. War crimes would also be erga omnes. So there's absolutely no legal issue. So whatever the states are ready to do politically, they should be doing. Whatever weapons they can provide to Ukraine to defend itself, they should provide. Whatever collective action they might take, they should take. So I think legally that would be the answer. The rest is for the politicians and the military. Thank you.
Thank you for that response. Ambassador Ray, if I may turn to you, there's a lot invested in the sense of expectation in terms of, and it's come up today, international criminal law and individual responsibility. There are, of course, also the requirements of due process. For example, the International Criminal Court prescribes that there can be no in absentia trials. Indictments, of course, are possible absent, but a trial can't be. So leaving aside even the aggression question, which would have to be addressed by some other institution, what can you tell us about the current thinking in terms of kind of expedited processes that can bring to bear, because I think we're past the deterrent effect. I mean, obviously it's not deterrence now, it's something else. So could you comment about kind of the current thinking and any ideas that might help in the actual situation?
Well, I think the prosecutor for the International Criminal Court, Mr. Khan, has made it clear, and having had so many countries referring the issue to him, has made it clear that he's prepared to exercise his jurisdiction to carry out investigations. The practical question for an organization like the International Criminal Court is, okay, where do I get the resources to do this? And I think what's happening now is that a number of countries that are supportive of the court overall, in all of its work, are joining together to make sure that the court has the resources that it needs to do the work that it wants to do. Having said that, and I'm sure lawyers will understand me when I say this, we don't direct the prosecutor. He directs himself. We don't tell him what to do. We don't tell him to say, investigate that case, don't investigate that case. We don't do that. And we have very strict rules against doing that. The Assembly of States Parties' job is to work with the court on its overall management and on its overall resource situation. Our job is not to tell the court which cases to take and which cases not to take. But I can assure you that we're taking the steps that will allow the court to do the job it wants to do, and to allow the prosecutor to do what it is that he and his team, the two deputy prosecutors with him, constitute the office of the prosecutor, what they intend to do. And that's exactly what's happening. And I'm glad to say that in my role as the vice president of the Assembly of States Parties, I was able to attend a meeting in The Hague where we had a discussion not about cases, not about individual situations, but to talk about what is the overall view about the resources that are going to be required to carry this out. Just briefly, there's a lot of other institutions that are being asked to do things. There are a lot of other investigations that are being promoted in a variety of ways. I think we have to focus a bit of our time and attention on the ones that have got a good prospect of success in terms of their ability to actually make good progress. Canada has been a strong supporter of the ICC as an institution. We think it's time that it was put to the test. So we're focusing some attention on that.
Thank you, Ambassador. I know that we've already gone over time, and I do want to pose one question to Ambassador, to Dr. Nölke before we conclude. And then I will say something about the now almost 40 questions we have pending for us. Ambassador Nölke, you mentioned about the processes or procedures available at the OPCW, for example, a commission of inquiry. Of course, that's looking forward and it will take time. Can you say something about in this kind of crisis situation, any measures there or elsewhere you can think of that could be helpful in terms of preventing the escalation? I think many people right now are deeply concerned about escalation. I mean, it is being threatened overtly. Are we totally at a loss, or are there some things maybe even creatively we could consider?
Well, as I think both Ambassador Ray and Dr. Gnatovskyy have already said, the law is there. It's a question of, compliance with the law. And Russia, I think, has made very, very clear that it is not interested. So in terms of legal means or statements or findings of fact, findings of law, they will not change Russian behavior. What might change Russian behavior is concrete measures. And that ranges from tightening sanctions to supply of weapons. All of these things are happening. One of the things that I mentioned in my presentation was the idea of actually using Russian frozen assets. In other words, instead of simply freezing them and holding them pending an outcome, using them now. In fact, seizing them, taking them, applying the money. And that is something that I think is in the hands of states unilaterally. You can simply, you may need to amend domestic law to make it happen. That is a possibility. We have, the Canadian government makes law. It could make a law now that allows the release of frozen Russian assets to Ukraine. It could do that if it wanted to. And of course, it would have to be debated in Parliament because these things have other possibly unintended consequences. You don't make that kind of policy on the fly in an emotional response, but it is possible. So it's a question of really choking off Russian capacity and Russian political will to continue on, because right now they have made it very clear that they're not interested in what the international community has to say. So tightening the noose, I suppose, I think is the only option. But the law is there.
Thank you very much. Yes, action, I think, is the order of the day. And maybe with some creative thoughts. I'm aware that we have now gone more than 5 minutes after, and there are certainly people, not least I imagine Ambassador Ray, you have many demands upon your time. So what I'm going to propose for the almost now 40 questions we've accumulated is together with the Ukrainian Canadian Congress and the Human Rights Research and Education Center at the University of Ottawa, we will take it upon ourselves. We've recorded this session. We have recorded, we have the text of the questions. We will prepare written answers, which we will post on our websites so that those who have questions, we will not reveal the individual persons posing the question. We will just reiterate the question, and we will post responses insofar as we can. Perhaps Dr. Gnatovskyy, you might join us in assisting in that exercise. So that it is visible, available to those who participated. We're grateful for those who have stayed past the period of time. We're still over 300 participants. And this recording will also be available so you can watch it again and you can see. We'll do our best to do that as fast as we can. I would just say watch for it and we will notify people. So it follows from me then just to thank again, our partners, the Ukrainian Canadian Congress, the Ukrainian Canadian Bar Association, the Embassy of Ukraine in Canada, Ambassador Bukevich, Ambassador Ray, former Ambassador Nölke, Professor Dr. Gnatovskyy, President of the UCC, Alexander Chudrich, the head of the President of the Ukrainian Canadian Bar Association, Jason Wojcichin. And let me also not forget to thank Orest for your tremendous work in the background here, ensuring that this was all organized. Thanks for your time. Thanks for your interest. And please do everything we can. This is an absolutely urgent and vital matter to all of us. Thank you. And our prayers are for the people of Ukraine.
Thank you so much. Good to be with you.
Thank you very much indeed. Thank you.
Take care.
Thank you. An honor to be with you.
Thank you so much.